842 United States Code, Section 1963, passed in 1870 as a Reconstruction bill. Is that about right?
That sounds about right if my memory serves me correctly. But Mr. Chairman, as I get a little longer in the tooth, my memory is not as good as it once was.
Okay, it does, however, provide that the employer specifically could be held liable. Is that right?
Yes, sir. It doesn't attach automatic vicarious liability. However, it does allow for a separate cause of action. And really, this bill that is before you now is much narrower than the original introduced version. And that section that you're referring to and asking about was really born out of the idea that oftentimes we'll be at public events, restaurants, bars, and we will see a sheriff's deputy or an off-duty police officer helping with security. However, the issue comes when they have their uniform on. They give the impression outwardly by the clothes that they wear that they are in fact on duty, members of a law enforcement agency, and so people are right to expect and believe that they are on duty. And so we were trying to protect against those situations where they might not be working for the actual law enforcement agency, but they have in fact worn the uniform that the agency provided and are giving the impression to patrons of an event or somewhere that they are members of that law enforcement agency. It's been narrowed quite significantly to allow for a separate cause of action, but not automatically attach the liability.
Now, is it true that this is the duty of the employer, the liability of the employer is not in federal law? Is that right?
I'm not sure whether that's in federal law or not, Mr. Chairman. What I would submit is that this bill does in fact allow for that as it's in the text of the bill.
Now, is it true that this would, I think there's been some misunderstanding about this bill, that in almost every case that I'm aware of, correct me if I'm wrong, that anyone that's being sued in this, it has insurance. That is, there's a liability insurance covering that person. Is that right?
Yes, that's my understanding, Mr. Chairman.
And right now, again, this is similar to, almost identical to federal law, except for the fact that you specifically said qualified immunity is not a defense to liability imposed in this section. Is that right?
Correct.
Now, the qualified immunity in this section is also in federal law, but not in the code itself. It's judicially created. Is that right?
That is right, Mr. Chairman.
And it's my understanding that qualified immunity that is judicially created in federal law, and it would be in this state code, would, or rather the qualified immunity that's in federal law that you would delete from this particular bill provides basically that the officer would be liable only in the case of violation of clearly established law. Is that right?
Yes, sir. I mean, but and again, I think the point is that qualified immunity or immunity defenses would not be allowed in those instances where we've seen, at least in the federal cases, where it is a extremely high hurdle to overcome to get past the immunity challenge.
Now, as I understand it, I've studied this somewhat, and I'm familiar with this area of the law, and I did some research recently. The area of the question of clearly established law is not that clear, in that it varies from United States Courts of Appeals to United States Courts of Appeals. That is, it's not uniform throughout the country. Is that your understanding or what?
I'm sorry, could you repeat that question again, Mr. Chairman?
Yeah, the question is, what is clearly established law? In some cases, from my research, some judges say it's got to be a case specific to the facts of that case before it can be clearly established. Other judges, it's a looser standard of what is clearly established. So it's not, at least nationwide, under federal law, what is clearly established is not that clear.
I think from generally speaking, that is correct. And I think the former description that you gave about having to be very case specific and fact specific, that each and every element, each and every fact has to be exactly the same in a case that has survived a qualified immunity defense, which is a big part of why it's so difficult to do that, overcome that challenge.
All right, thank you. That's the only questions I have right now.
I have a couple questions.
Any other questions from members of the committee?
Mr. Chair.
Mr. Chairman.
Senator
Peterson.
Senator Stuart.
Thank you, Mr. Chairman. Delegate Bourne, I'm not an expert on qualified immunity, although we've had a pretty robust discussion about it today with regard to another bill, and I've learned a lot. But as I read your bill, I just want to make sure I understand it. This bill would actually apply if an officer makes a mistake in judgment. Is that correct?
I think all these, I think if the officer violates the constitutional rights that are established and clear, then this would allow a lawsuit to survive and not be subject to qualified immunity as a defense.
Mr. Chairman.
Yeah, Senator Stuart.
So, Delegate Bourne, given that officers have to make split-second judgments all the time in very difficult positions where their lives are on the line, they could be held personally liable and sued for everything they and their family have, basically become impoverished from a mistake in judgment, and it doesn't even require an intentional or malicious act on their part. Is that correct?
Mr. Chairman, I would say at least three things. One, I would recall your question about these officers being covered by insurance, one. Two, I would suggest to the senator that most of these cases involving constitutional rights that are being, where justice has been denied, do not involve exigent or split-second decisions. I point to the example in Kenosha, Wisconsin. There was nothing exigent about that young man walking to his car away from several officers and being shot 7 times in the back. And so I would say that this, again, finally, just does not put the thumb on the scale of justice. All this does is say that you are not going to absolve yourself of accountability, you the officer, you the employing agency or employer, by using a judicially created defense with its roots in the Ku Klux Klan era.
Mr. Chairman.
Senator Stuart.
Thank you, Mr. Chairman. Delegate Bourne, I get that. I don't disagree with you when you're talking about shooting an individual in the back, but that's not what we're talking about in your bill. What your bill says is any law enforcement officer who under color of law subjects or causes someone to be subjected, including failing to intervene any other person, to the deprivation of any rights, privileges, or immunities granted to such person under the Constitution and the laws of the United States and Commonwealth, shall be liable to the injured party for compensatory damages, punitive damages, and equitable relief. I just want to make sure I understand your bill, because I'm not talking about anybody who commits an intentional act and does it unlawfully, as we have seen highlighted on the news, should be subjected to all of the things that we've talked about. But this allows an individual who simply makes a mistake in a split decision to be sued and to lose everything they have, and insurance only covers a certain portion. This allows them to be sued for everything they have above the insurance limits. Isn't that correct?
I would submit to Mr. Chairman, I would answer the senator by saying, again, he noted the insurance. Two, again, this does not automatically attach liability. This allows the case to be heard on the merits. The judge or the jury is going to decide what the liability is, if any, and then what the level of damages are. It is going to play out no differently than another civil trial where damages are at stake. There's a liability portion of the trial, and then there's a damages section of the trial, unless, of course, obviously the plaintiff concedes to liability and the trial is really just about damages.
Mr. Chairman, one
Senator
final question.
Stuart.
One final question, Mr. Chairman. Thank you. Delegate Bourne, given that the parameters of your bill, and I think we all understand it now, I have one simple question. Who in their right mind would serve as a police officer if they had to be subjected to the kind of liability for errors in judgment and not intentional acts? And how will we ever get people to serve in the police force in the Commonwealth of Virginia?
Mr. Chairman, I would respond to the senator by saying, one, that there's been a lot of discussion about this bill, and I've heard from the opposition that we don't need this because you can already sue a police officer. Well, that would be part of my response to the senator. Two, if in fact the actions of the officer were lawful, then there's no constitutional violation. And then, so I think we are really trying to give folks access to justice. That's really what it boils down to. I don't suspect that my testimony, my answers to these questions are going to change anybody's position on this bill. But nonetheless, each year we all come here to do what we think is right and represent the people that elected us. And this is one of those bills that despite some strong opposition and some shenanigans that went on, I'm here. And depending on the outcome, hopefully, access to justice will no longer be further denied in this vein.
Mr. Chairman?
Mr. Chairman.
Mr. Chairman?
Senator who? Deeds? No. Senator Morrissey.
Thank you, Mr. Chairman. Delegate Bourne, I first want to thank you for the work that you put in this bill. I know